Morning, everybody. We're starting with our first session today, and the chairman will be Professor Henrik Røsæg. Henrik, please take the floor.
Thank you very much. Good morning, everybody. Hope you're all rested and fresh for a long and interesting and fascinating day ahead of us. The first session is focusing on liability regimes for mass. We touched a little bit upon that topic already yesterday, and today we go dive into it in more depth. And the first speaker is Professor Erik Røsæg from University of Oslo. So, please.
Thank you. It's always a pleasure to be here, and I can say always because I've been there once before. And I really like this topic, and some of you will know I've written about it in this book called Autonomous Ships and the Law, edited by, for example, Erik Røsæg. My topic today is about the existing liability systems and the challenges of mass in that connection. At least two speakers have already covered that quite extensively. But I think they trusted that I had some alternative views because I often have. And yes, they're right, I have. So we'll see what we can get out of this topic. In particular, if I can change my slides.
Page down.
I try that.
You need to click in the presentation button now and then you can.
Yes. Yeah. So we have quite a few conventions here, and they mainly, or those I will speak about, they deal with damage to third parties outside the ship, and I think we all think about collision in this connection, so let's keep that in mind. But there are also things about pollution, for example. And as already has been mentioned, there's no general convention on the basis of liability. That's really surprising. And in the legal committee in the mid-90s, and I'm talking about 1990s, I was there, and we discussed whether we should have a new wall-to-wall cover of all liability issues, a new convention. And that would be kind of nice in a way, because then we could get these pieces to fit better together. But on the other hand, it would be a long-term project. And I just foresaw that if we started that in the mid-1990s, I wouldn't be able to finish that work before retirement. So and most people agreed on that. So there is no general convention on the basis of liability, but it's quite typical for maritime liabilities that they are negligence based. The strict liability regimes, they are exceptions. And I think we can just assume that in most countries the law will be so that the ship owner or reder has a negligence liability, and it's not based on uniformity, but in most countries there will be vicarious liability for people either employed by the ship owner or a little wider people working with the ship. So that's the starting point. That's what we're going to compare with. And then we have limitation regimes, global limitation, and other regimes. Could those be affected by autonomous shipping? We'll have to look at that. We have pollution regimes, for example, strict liability for oil pollution. Would that be affected by mass? And the collision convention, of course, from 1910, has already been mentioned, and I will say a few more things about that. UNCLOS, does that is that important in this context? Well, it doesn't really deal with liability. It just refer liability issues to the state parties. So I don't think that's really important in this context. We couldn't discuss maritime liabilities without discussing insurance, and some other people will say more about that. But we have to involve both P&I and hull insurance, because although we think primarily perhaps about collision situations, that will affect both kinds of insurance depending on which regime you have. So usually that will also, or in many countries, that will also affect hull insurance. And we need to get this liability system to fit into what is insurable. And luckily, I think insurers have decided that they will be positive to autonomous shipping. That's probably because ship owners are interested and they are their customers, or indeed owners of P&I. And then there is this important clause, the cyber clause, that surprised me that it still does exist. And it could look like this. This is a version from, as you see, from 1903. And this is important, for example, because it's one of the exceptions an insurer of passenger liability can make under the implementing provisions of the Athens Convention. In no case shall this insurance cover loss, damage, liability, or expense directly or indirectly caused by or contributed to by or arising from the use, operation as a mean of for inflicting harm of any computer system, computer software program, malicious code, computer virus, or process, or any other electronic system. Wow. That means that there is an exception here for example, a virus in the computers of the autonomous vessel. The ship owner cannot insure against a computer virus. And he will, in many cases, be relieved of liability as well. And of course, this is dangerous for ordinary vessels, but for autonomous vessels, which rely heavily on computers, it's extremely more serious. And I've been very worried about this. And in 23, we were still thinking about the turn of the century and what could happen then. Nothing happened, but we were all worried about it. And it was right after 9/11. We were very concerned about the insurance market. Insurers are always concerned, that's the profession, but I think it was more recognized that there were reasons to be concerned at that time. So this clause was accepted. We had to accept it to get the Athens Convention, for example, into force. But today, it's not that widely used. And in the Nordic plan, for example, there's no general cyber attack exclusion clause. So we had this very strange situation that the only place it survives is for passenger liability because of the implementing agreements in connection with the Athens Convention. But in principle, it's important to deal with this and see whether we can get liability and insurance also for computer vulnerabilities. There's no reason today why a ship owner relying on computers should not also take the risk for those computers. He has to protect himself. I've taken an initiative, just as a private person or a private academic, to initiate discussions with the insurance market on which of these clauses in connection with the Athens Convention, which of these exceptions are still necessary. These talks are going on, but I think perhaps we'll see some kind of revision of this. But as of this time, this is a problem. And then we have this general negligence standard. Moving away from insurance, and we're going to the basis of liability. And if an autonomous vessel is fully autonomous, can it be negligent? If there's negligence liability, and a machine acts, a machine figures out how to navigate, could it be negligent? Well, it doesn't fit very well with our concepts of negligence and diligence, does it? So we have a problem here, and it's not a convention, but it's based on national law, but it's sort of as a convention because this is how it's conventionally is done. On the other hand, a machine cannot be diligent either. So what's the basis of liability? Is it to be negligent or not being diligent? Wouldn't help to turn the question the other way around. If I had to choose whether to trust a master or to trust a machine, I think trust the machine. There is some skepticism because of bad programming, etc. But a well-tested computer, it's much more reliable than the master. The master may have been partying the night before. Computers never do, unless they're programmed to it. So we have have this situation we have to deal with. And sometimes one would use perhaps fictions. Lawyers love those. So we can have the fiction that, well, this really acted as a negligence master, this machine. I don't like that. I think we should have rules that where we do not have to think, well, need to do as if, etc. Because if we use fictions, we sort of have a very unclear rule. So we have to avoid that. And then we can have burden of proof rules. Of course, that will help because we don't have to prove negligence or diligence. We just have to look at what happened and say, well, this looks like negligence. But sometimes one could actually fulfill that burden of proof, saying that, well, here are all the details of the system, and there's no negligence here. So it doesn't help us really, because we don't get away from the base problem of negligence. Strict liability, perhaps. Perhaps that would be the way out. The Collision Convention abolishes strict liability. And it has been mentioned, but let's look at the clauses here. And they refer to, or the Collision Convention refers to if two or more vessels are in fault. So the term is vessel in fault. And there are several provisions referring to the same thing. And we all agree that this is a reference to the national negligence standards, hopefully sort of harmonized. But it doesn't say very much about vicarious liability, does it? The vessel itself cannot be at fault. So this is like the same problem as we discussed in the previous slide. So it's assumed that the vessel has responsibility, liability for negligence and negligent acts of others, but that doesn't really say who. Doesn't define whether, for example, there is a collision liability for the negligence act of the computer program in a mass. That's decided by national law, but it should at least be clarified. However, pure strict liability is not possible under the Collision Convention. One expression of this is Article 6. All legal presumptions of fault in regard of liability for collision are abolished. So you cannot presume negligence, and you cannot get away from the negligence standard. So the Collision Convention does not allow strict liability. Perhaps we should just abolish the Collision Convention. What would happen then? Would the Twin Towers fall? Would things go really bad in the insurance market? I think so. I mean, this is a 1910 convention, and it's about harmonizing, nothing about rights of one state in relation to another. So if we abolish it to allow strict liability for for mass, well, we can keep it for the rest. But of course, if we abolish the convention or the international ties of the law here, then perhaps we'll see, well, this was really a convention designed to remedy a fault at common law, that if a person who had been negligent could not invoke the negligence of the other party. So one should come up with a shared liability depending on the degree of faults on either side. That is not longer very controversial, neither in common law nor in other legal systems. So perhaps the collision convention really has done its job. Maybe we don't need it anymore. So that's a possibility. If there is a strict liability, if you want that, we will need a legal basis for it, perhaps some exceptions. In most countries, it's okay that the courts find negligence liability, but not all courts have been very bold in establishing strict liability. The Norwegian Supreme Court since 1905 has been very eager to establish strict liability. No problem. They started, it came gradually, but the first clear case was perhaps when a water pipe burst. And of course, the water company had to be liable for that, they said. Strict liability. We don't have to prove negligence. But one would need, perhaps in most countries, an express basis. But the problem here is that with mass, if we give them strict liability, they will get too much liability. There's no reason why if I get a mass running into my starboard side, I had to yield for it, but it runs into me, and I can say, well, I had to yield for you, but you are liable because you're a mass. The strict liability. So we don't really resolve our problem by giving strict liability. It's too much. Unless, of course, we wish to alter the situation drastically in liability. But I don't think we want to do that. So I wish to introduce an analysis of the objective and subjective parts of negligence. Objective in the sense no fault, and the subjective parts having to do with the subject, the faults of the person. And the standards of navigation, they are objective as a starting point. So the ships should sail and it should follow the colrex, for example, and yield for ships on the starboard side. The subjective part comes in as excuses. That's, of course, you have to yield for a ship on the starboard side, but there may be situations where you can be excused. Perhaps if it's not possible to yield, perhaps if the other ship, for some reason other than the weather, was invisible, something. or perhaps the master fainted or something like that. So there are subjective excuses. There may be situation where the objective standards of navigations are violated, but there's still not negligence liability. And I think our way forward here will be to look at the objective standards. And we will know that things can go wrong. These are not solutions to every problem. And it does happen that ships collide. It may be that the master has been negligent. And if the master is diligent, we will avoid most collisions, but it still can happen. It can happen, for example, because the master gives order to reverse the machinery to stop the vessel, and there's a technical error, so that doesn't happen. So, but I think that's enough. So what we need to find is what is the objective standard, the optimal effort to prevent accidents. And I think we should investigate this objective track, which is the not strict liability in full, but it's the objective part of the negligence standard. So here's a graph made by a colleague called Chauvel. I think many of you have seen it before. And if I'm very lucky, I can be able to draw a little on this. Yeah. So in the graph here, you have losses in dollars at the y-axis, and at the x-axis, we have degrees or units of precautionary measures. We don't really have a unit for that. We have volts and farad and ampere and ohm, called after great scientists for other things. So I suggest that the unit we use for precaution is 1 VO. And so we don't have really to worry too much about what is this. And then we say, if we have more precaution, then perhaps we will have a better board. So this is the line of precaution. And you can see that it's more expensive the more precautions you have. Okay? And I think lawyers would tend to say, well, the more the better. You can never be cautious enough. But yes, you can. I mean, it's we all stop at some moment and say, well, this is enough. And the point here is to find what is the right level of precaution. There could be too much precaution. And I'll illustrate that by looking at the losses. If you have no precautions, perhaps the losses are very high. But the more precautions you put in, the less the losses. And if you sum up these two lines, then you get the third curve here. And you will see that at some point, this starts to turning upwards. Why is that? because you use a lot of precautions that are not very efficient. They will not really reduce losses. And what you want to do is to have the level of precaution where the total losses for the society, the losses by accidents and the losses by precautions, you wish to have that at a minimum level. That's how you wish to think here. And if you go to rely on the on the objective part of the liability on the negligence standard, the objective part of the negligence standard, that's exactly what you wish to achieve. The ship can sail, not too fast, not too slow. And I don't say that it's practical to find this line here. But what I say is that you wish to have some precautions, but not all possible precautions. And that's what we are looking for here. Thanks. And if I'm very lucky now, I will be able to proceed here. Yes. Yeah. So alternatively, one could look at the subjective track, and we can look at who's responsible for system design. That will usually be some engineer many years ago at a shipyard. But as important as that is, who's responsible for system maintenance? Because an autonomous vessel will have to be maintained. There have to be new data put into it. And of course, any computer system would have to be maintained. So it's we have this problem that while the master is the master of the vessel, an autonomous vessel has several masters: the designers, the maintainers, etc., etc. And we have this important problem of time limitation, because when I sit at my desk and I design an autonomous system for a vessel, I shouldn't expect to be sued for errors I do, even if they are clear errors. I shouldn't expect to be sued for those 20 years later or 40 years later. So while the ship is running for 20, perhaps 30 years, of course, the time limitation runs out. And we cannot let ships sail without liability. And then we have this challenge with the global limitation system. Doesn't matter there whether it's a negligence or strict liability for privity, for breaking the rules. It does require a lot of negligence anyway. But wouldn't it hurt the system if suddenly the designer of an autonomous system could be held liable? Because this designer doesn't have the right to limit. So suddenly, the people will try to sue the ship wharf rather than the ship owner. That would require redesign of our system. So we have perhaps a better choice of at least primarily go for the objective track here. There is a problem to figure out what is the standard. And the test would be, would the marginal cost of 1 unit more of precaution, would that be more costly than the accidents you can or can avoid, or the marginal costs of accidents? I cannot offer sort of a clear-cut answer to that in all cases, just as little as I can say, what does it mean to be negligent? But this is what we should look for. And there's no room here for subjective excuses. It just have to be at a decent standard. And we have to attribute this to someone, and someone else is going to discuss this, but we can attribute it to the owner of the vessel or the reder, the one who runs it. And many examples of provisions like this in Code Civil. It's well known that there is a thought that perhaps one should be responsible not only for employees but also for the things. There are some principles of European tort law, and they have a rule of enterprise liability. This is just what I'm talking about. You have the risk of the enterprise you're running, not strict liability, not vicarious liability, but the risk for the damage it causes. In product liability, we think about this as strict liability, but if you look at it, it is really the same kind of thought. There is no subjective excuses, of course, but you have to have a reasonable safety standard of the product. So this is well known, and we can use this for mass as well. I think we could use it in the current law. I would have no problems with that. This is from Restatement Second in the US, and they have actually enterprise liability there. So they say that you have, for a risky business, as shipping is, you have liability, not only for your employees, but wider than that. So my conclusion is that it's possible, not necessarily compelling, but it's possible by examples to sort of choose this objective part of the negligence law. When it's possible and it makes sense, I think we should do that. I see no reason why we shouldn't put this liability on the ship owner, as usually is liable today. He's probably the cheapest cost avoider. He can avoid these accidents in the cheapest way. It may require a denunciation of the Collision Convention 1910. I wouldn't cry a moment for that. And this solution will work well with other conventions, and it will work well with the rules of time limitation. So that's my solution. Thank you.